It's swirling. Here we are. Okay, welcome to the club meeting. Glad to see everybody here in person, and for those of you that are on the stream. So I'm getting a shake of the head. Well,
Oh, there we are.
we are fortunate enough to have our very own instructor here to speak, and I'm excited and can't wait to hear what he has to say too. And I learn a lot in his class. And that's it. Please keep coming back to our meetings. Like, we keep bringing snacks. So don't be shy. Go ahead and help yourself. Okay, I got to do a filler. Let's see. So I can tap dance.
Just so we know, how did everyone find out about today's meeting? Class?
Email.
Email? Which email? Was it the paralegal newsletter or was it our email?
Paralegal newsletter was the first.
Okay.
And announcements.
Yeah,
Announcements, okay.
that seems to
Just
be.
so we know where.
I think Kathy keeps forgetting to put the club up on the announcement.
Oh, okay.
But she always reminds everyone of the Saturday morning.
Oh, that's good.
Oh, nice. Yeah, this is, you learn something here. I mean, it helps further what our goal is, and then we get to know each other too. It's nice to walk into a room and go, "Hey Jay, how are you doing?" You know. And I knew she was shy about snacks, so I shoved them on her.
Okay, we're having issues. It's not letting me in.
Uh-oh.
Oh, there you go.
Are we good on
Before.
Yeah, you're live. We're live. And
Anybody know the workaround to this?
Can you just close that, the pop-up, because the slides are there?
you sign into the thing with your school email.
Okay. You have to do it at every
You have to do
computer.
it every single time.
Oh.
And sometimes it just takes over.
Okay.
Yeah, something. Yes,
yes.
Ah,
Yeah.
all right. I don't know how accurate this title is, but we'll go with it. So I know several of you. My name is Shawn Jensvold. I teach legal research here in the falls, I guess now. I've taught one form of the class or another since 2011, so it's been a while. My day job, night job, early morning job, whatever you want to call it. I'm a prosecutor. I'm a capital prosecutor now. I was bureau chief over major crimes. I'm in Pinal County. I've been there since 2013. I had 2 years of doing civil litigation for a local PI firm. If you've seen buses around town, you probably know. Anyway, let's just say it wasn't a good fit. We'll go with that. So I did that for 2 years. Prior to that, I was 8 years with Pima County. So got my feet wet as a prosecutor with Pima County. Went to law school at UC Davis. I had a career in the biotech industry of all things before that. My undergrad's in microbiology. So there's a long story about why I decided to go to law school, which I won't bore you with. But anyway, so I've been doing this for almost 20 years now. I've been doing mostly sex crimes and murders for, 15 years, I suppose. So that's kind of my perspective. So question, why are you still doing this? The number one reason why I'm still doing this as opposed to going off, I've had a couple of opportunities for judgeships. One didn't work out. Maybe that's a possibility still, we'll see. But anyway, I think the primary motivation is just the impact that you can have as a prosecutor. On an individual level, I mean, there are frustrations with every job, as you all know. So especially, you can get bogged down to the details of administration and policies with the courts and all that stuff. So no career is perfect, as I'm sure that comes as no shock. But the upside to being a prosecutor, at least as I have found, is the impact that you can have, not as much globally, but you can have an impact on individual cases. And I know that the experience that I've had learning from some not guilty verdicts, some mistakes that I've made in the past, you can see how your experience can lend itself to, the administration of justice on individual cases for sure. I was out at, this is a small thing. There was a homicide that occurred in Santan Valley outside of a bar on early Sunday morning, so I got called out. The police were going to charge first-degree murder. That's just by default. And then as we looked at the video and stuff, and I'm thinking like, you guys, this is second-degree murder. Really, it's second-degree murder. There was no premeditation. So we give advice to law enforcement all the time about, what charges are appropriate. Do they need more evidence before we can even file a charge? All those kinds of things. So, we do have an advisory role with the police that we can have an impact on. But let me just highlight some of the sad and tragic cases, sorry, spoiler lunch, that I've had. But these are some of the ones where I remember the most. This is 2-year-old Colin. That was photos taken by his grandparents. This is 2013. Unfortunately, Colin was killed. Colin was killed by his mother's live-in boyfriend, James Sunderland. You see his picture down there, taken it during the investigation. Why he's smiling in his DOC photo, I'm not sure. He and Colin's mother were both addicted to heroin. Colin's mother turned a blind eye to the abuse in several different stages before it led to Colin's death. She was charged with child abuse, but he was charged with murder. We had multiple witnesses from Phoenix Children's Hospital come in and try to explain. He didn't admit to what he did. One of his lines to the grandfather was, excuse my French, but he goes, what do you think, I beat a fucking 2-year-old? This was before he killed him. So anyway, so that was 2013. Mr. Sutherland serving a natural life sentence. The grandparents, I still communicate with them occasionally, and even tragic upon tragedy is that their daughter, the mother, Colin's mother, died of an overdose just last year.
What were the charges?
First-degree felony murder plus various counts of child abuse for him. She had other counts of child abuse for basically failing to protect Colin at various stages in the months leading up to his death. She wasn't there at the time of the death. She was off. She was working as a lifeguard. He wasn't doing anything but supposedly taking care of Colin. So she didn't know about what happened on the day of his death, but she had culpability for stuff leading up to it.
So she had been charged prior to child abuse? She had been charged prior to...
No, she was charged basically all at the same time. The prior incidents weren't brought to law enforcement's attention.
Who were they brought to attention to?
Well, the grandparents knew about some of it. And then there were, and it was all, it was superficial injuries. I mean, they were exterior injuries, but nobody called the police. The grandparents thought they were going to handle it. They were flying, it's a long story. They were flying back and forth to Alaska, so they weren't there full time. They noticed some of the injuries a few weeks before Sutherland killed Colin. And you can imagine the guilt that they feel. That they were still working for BP up in Alaska. They were in the process of moving. But
Child Protective Services was never involved prior to
CPS was never called. No.
And that was because the grandparents or the parents or no one called?
Well, yeah, the mother certainly wasn't going to call CPS on herself. And she just kind of looked the other way to the bruises and stuff that Colin had.
Did she serve anything?
She served a small prison sentence, yeah.
And probation or
She had a probation tail but she fell back into drugs, which is not surprising considering her history. I didn't know that Alaska in various neighborhoods the drug addiction in Alaska is very significant from what I understand. This is a cold case. So our male victim here, there's a female victim who's not pictured. This is a case from 1990 when it happened. So prior to forensic DNA being around in any form, in any legitimate form at that point that was useful for identifying a suspect. So this case, female victim, middle of the night, somebody's pounding on her door. for whatever reason, she cracks the door open. Instead of just, staying behind doors, she cracks it open. A black male barges in, grabs her, beats her, and then goes back to the bedroom and shoots and kills her boyfriend, and then sexually assaults her, and then leaves. She has no idea who he is. She describes him. She describes like kind of, braids in this guy's hair in 1990. That's Mr. Tamplin still wearing braids in some form, 15 or so years later. So basically the case goes cold. There's a cold case unit formed in Tucson Police around 2005, and then the Pima County Attorney's Office also formed its unit around that same time. We were working with TPD and PCSO, primarily Pima County Sheriffs, on some of their old cases, and there were a bunch of unsolved murders in Tucson in 1990 for whatever reason. There were other years too, but there were a bunch of them, on 1990 in particular, and this is one of the first ones they looked at. That circle down there, so there was blood found on the carpet. They sent that to the DNA lab. They get a CODIS hit, and Mr. Tamplin's DNA profile was in there because of other convictions. He was set to be released in 2018, I think. So maybe even sooner than that. We charged him with first-degree murder, sexual assault, kidnapping, and other offenses. So he's now probably never getting out at this point. He was convicted of first-degree murder, so he's not getting out. But that was an unsolved cold case that we had during my time in Pima County right before I left. This is a more recent case that I've had from Pinal County. If any of you watched the show Snapped, there's an episode about this case in which I interviewed. Brilliant commentary, not so much. They could have gotten anybody to say what I said. They didn't cover the stuff that I thought was interesting about the trial, but whatever. It's TV, so Michael Agater was from Ohio, moved out here in his early 30s. He was doing real estate finance. He meets girlfriend Catherine Sinkovich. Relationship goes well for a while. Then all of a sudden she turns into someone that he doesn't want to be with, and there's a few domestic violence incidents. They're accusing each other, but he's got stitches on his thumb where she bit him during an incident. And then she's pregnant. This is 2016. December of 2016 is Michael's murder. But before that, after they had separated, she then says that. So she says, "Oh no, Michael's really not the baby. Michael's not the father, even though she knew that he was." So he files a paternity suit for custody, and it's in the process of that that Michael, on the day that he's murdered, goes down to submit his DNA sample for the paternity test. Between the two attorneys, Catherine Sinkovich finds out about it, so she has an idea of when he's going to be coming back home. She's at work for a place, another real estate place in Tempe. Michael lived in the city of Maricopa, which oddly enough is in the county of Pinal, not in Maricopa County, but anyway. So the city of Maricopa up there by where one of the casinos is. So he lives there. She lives in Tempe, probably 25 minutes away or whatever. On the day in question, Michael goes down to get his paternity test. He's on the phone with his sister in Ohio, telling her about what's going on. He pulls up into his driveway, and as soon as he pulls in, he's got surveillance video on the exterior of his house. You can see a female in a hood. You can't see her face, but she's driving a white minivan across the street. It captures that. She scurries across the street. As soon as he pulls in, she shoots 3 times, hits him twice, once in the head. He's dead right away. And then you see her scurry back to the minivan, the minivan pull away. Immediately after police, there's several 911 calls from neighbors going around. They get in touch with his family and his friends here, and they both say, "Hey, you better take a look at Catherine because of all the incidents that have preceded this." And as the investigation goes on, they find that there's a white van that's very similar that belonged to Catherine's friend at the company that she was working with in Tempe. And they checked the surveillance video, and sure enough, Bridget was the name of the friend. She had driven the van to go to lunch, brought it back, and then you see Catherine take the same van going out the door. Take the van, and she's gone for about 3 hours, right around the time of the murder. She turns her cell phone off, so they can't track her that way. And you don't see her face, but you can. One of the creative things that we had to do in this case was try to narrow down this minivan. You couldn't tell exactly what it was. You couldn't see a license plate, but there were enough features about it where you could narrow it down to a Chrysler Town and Country, I think, and even distinguish it from all of their minivans just because of some features. We brought in an auto parts manager at one of the local Dodge dealerships, Chrysler dealerships, and he was able to tell the jury, look, here are all the reasons why this is a Chrysler Town and Country between 2008 and 2010. Sure enough, Bridget's van was a 2009. So we were able to narrow it down, enough. But Ms. Sinkovich made some pretty incriminating statements to a phone call that the police were involved in with Bridget. She says something to the effect, well, they don't know, because the police were thinking Bridget might be involved in this before they saw the video. And Catherine tells her, well, if I took your van, they don't know that, and they don't have anything on you. So it's like, yeah, she's basically admitting that she took the van without saying in so many words. So that trial went in 2018, I think. So Ms. Sinkovich has got a life sentence. This is my most recent trial. This is a case from 2012. It took a long time to get this case to trial. It was a capital case to begin with, which delayed procedurally. And Mr. Aldasari, who's our defendant there, had several issues, competency issues that had to be resolved before he was finally determined to be competent. This is Arizona Grain, which is also in Maricopa. It's in there's a rural area between Casa Grande and Maricopa. So they basically take corn from the rail cars, dump it down beneath this little building here, and they convey it up there and process it in those towers and stuff that you see there. So Orlando, who's our victim, he had been working there for a number of years, and for a while he worked with Mr. Aldasari, unloading the grain and doing other cleanup stuff. Sometimes the trains would come in the middle of the night. So on our day in question, November of 2012, it's like 2 a.m. Orlando and a coworker are just emptying the grain, and they see a guy come in wearing a ski mask, all dressed in black, and he shoots and kills Orlando and points the gun at the other guy, but then he takes off. They have no idea who it is at first, but then later, Mr. Aldasari tries to blow up the Social Security building in Casa Grande, and then they flash his face on the news, and some of the co-workers there say, hey, that guy used to work here. So long story short, FBI serves a search warrant. FBI is investigating the Social Security office bombing. They go to his house, look up in the attic. There's a 9mm, and we had a 9mm casings at this case. He's got some shoes that match some shoe prints there, and then they send him out. The bullets match the gun that was in Mr. Aldasari's attic. He never made any statements. He didn't want to say anything, but there was a pretty convincing circumstantial evidence in that case. This one, you'll recognize the guy in red there, I assume.
Oh, God.
Oh, my God.
This is some of you who've been around here long enough, this is the 1996 car bombing murder of Gary Triano, who's pictured there. That's Gary. This is a really long story and a really long and interesting trial. There's 2 Dateline episodes on this case. I participated in the investigation as well as the case against Ronald Young. I had left the office before Pamela Phillips was tried. She was in Austria at the time that the case was charged, and so we had to extradite her from Austria. So Ronald Young was here, so we went with his case first. The extradition took quite a while. Short story is that Miss Phillips and Ronald Young met in Aspen. Pam and Gary used to vacation in Aspen. Gary was a local real estate developer, so he had plenty of contacts, plenty of sketchy contacts as well, and so that was part of the defense. But she hired Ron to kill Gary, and Ron decides to creatively blow Gary up in his car as opposed to shooting him. He did have a shotgun in his van. A lot of anyway, and then after the fact, the reason why the case was eventually charged. The murder was 1996. The case wasn't charged until 2008. Ronald Young, his chiropractor, turned him in after America's Most Wanted episode. He's in Fort Lauderdale, Florida at this time. For some reason, the reason why he keeps all these transactions and communications with Pam is because Pam had stopped paying him on time and according to the schedule that they had agreed to before the murder. And so he's using it as leverage with her. There's all these emails, all these voicemails and so forth. One of the voicemails that was famous was Ron tells Pam that you're going to be in a women's prison for murder. And he had a file where he had said it was mine when it was earned, meaning the money. He explains to her why he should get interest on the payments because she got interest from the insurance company when it was paid out.
This is all in writing?
This is all in writing, yes, yes. So he had all this evidence with him in Florida, basically to keep Pam, to keep paying him because she started blowing him off. So anyway, and this picture, just for your amusement, was taken. So this is President Trump's second wife, the wife with whom he cheated on his first wife, the mother of his kids, I think. Marla Maples, I think that's her name. She and Pam were college friends. So this picture must have been taken in like the early 90s, I assume. So they were hanging out with those guys. This is the picture. This is what just a small pipe bomb can do to a car. Can't get it, obviously. One of the most impressive things about this whole investigation was that the ATF was able to see that picture of the bag. They were, from all of the small pieces of evidence that they collected from the scene, they were able to piece together the bomb, the battery, all the components of the bomb, as well as even down to the type of duffel bag that was bought at Walmart. They were able to put that all together, and we were able to show that to the jury during Ronald Young's trial. This is a sex case. It's one of the most disgusting sex cases I've ever dealt with. This is Johnny Bollinger there in orange. I don't have a picture of his not so lovely wife. They were hours and hours of them both having sex with two of their daughters. One was his daughter, biological. She's pictured there. The other one was her biological daughter. They're smoking meth, and on tape, they uncovered, there were hours and hours of this stuff. I mean, fortunately, I didn't have to watch it all. The detectives did, and I feel bad for them. So, yeah, they found, and there were two boys in the house as well. They were not sexually abused, but just mentally abused. But anyway, putting Mr. Bollinger's never getting out, thank heavens. His wife is not either. What's that?
Are they both have life sentences for this?
She has a term of years. She'll be very old if she gets out, if she makes it. He's got so many years on him that he's never getting out. But, so yeah, that was the hours and hours of video, and at some point, his daughter, who's pictured there, he's questioning her about what she wants to do with her life, and she says she wants to be a porn star. So some of these cases are these is here just because I'll never be able to erase some of those images in my mind. And this one, another sex case, I just want to give you an idea. So Mr. Jackson here is biological father to all three of them. I put the brother in there just because these sex cases, especially if you have even victims who are not actual victims of the sex abuse themselves, they become victims because they end up in this impossible situation as to whether to believe their siblings or not, and then their allegiances are divided, and just it affects. I mean, these sex abuse cases just have impacts that go on forever. But short story to this one is, I'm going to show you a couple of video clips just to kind of give you an idea as to how sometimes this will play out in court. So Alexa on the right was the quote favorite. Jesse on the left, there was basically just one incident of physical sex abuse with her, but it started, well, I'll go through it. The first clip, Alexa will give a snapshot or a nutshell of what the entire case is about. So to set this up chronologically, it started when she was about 7 in Colorado. They moved between Colorado, California, and then finally they moved to Arizona in around 2000. Biological mother was on drugs, and so he got custody of the two daughters, and then he married their stepmother, and he was with them for several years, and then they got divorced because he was cheating on her with with her best friend. They didn't know about any of this that was going on with Alexa. They had their suspicions, but no one was able to, and Alexa frankly denied that things happened when she was asked. But finally, she starts to not give in to the sexual abuse when she's about 16, and then they know the friends that they were staying with, there's domestic violence incidents, they're fighting all the time, and finally, they were both arrested in April of 2005, both she and the defendant, for a domestic violence incident. And then after they let her out of the juvenile facility, she calls her biological mom, who has since cleaned up, and she's living in Oregon. So that's basically the only place she has to go. So she goes up to Oregon in April of 2005. She's still communicating with the defendant, as you'll see, and it's not surprising considering how long things have gone on. But eventually, she discloses to the police after Thanksgiving of 2005. It takes several months, but this is backwards. So this is what's called a forensic interview. It's taking place in it's what's called a family advocacy center in Portland, and this is February 8th of 2006. So this is the first time that she's ever able to tell someone exactly what happened in its entirety. And so you can see, the interview starts about 11 o'clock, and she's got a sweatshirt on. You can kind of see the sweatshirt there next to her in red. See all this down here? These are all Kleenex. I was able to use some of this during trial. There were only small portions of the interview that I could use to get around the hearsay objections, but all these Kleenex are her, sobbing during the interview. So the interview's about an hour long.
There's only parts of it you could use. Why?
Because it's hearsay. So, she has to testify about what events really took place. So we don't get to play the interview if she's there. We have to have her on the stand describe what happened. See what I mean? About the sex acts themselves. So we can't just play the interview. I was able to play portions of it that were not dealing with the allegations of sexual abuse itself, because they weren't technically hearsay, and because the defense was arguing that she was lying. She was lying because she was mad at the defendant that he wouldn't buy her a car to bring her back to Arizona. She was manipulated and a bunch of other stuff. So I'll show you the clip that I was actually one of the clips I was able to play. But you can't just go on and play the interview if the victim remembers what happens. There are some exceptions. If a child's really small, let's say a child's like 5-6 years old, and has an interview, and then years go by and the child just says that he or she doesn't remember what happened, then there are rules that allow for the interview to be played to refresh that witness's recollection. But she didn't have any problem remembering. She was a very good historian, so we can't just use the interview
So
itself.
you can't use an interview as evidence if it's hearsay. They have to actually get in front of the court.
If it's at trial, for the most part, yes. I'll show you one clip that I was able to play, and there was one other clip that I don't have. But yeah, so for the most part, you can't just play the interview unless the victim doesn't remember. That's the hearsay rules. When you take Gwen's class, I'm sure she'll cover some of that. But let me so this is towards the end of the interview. She's already described all these incidents going back from the time that she was 7 years old. So the first comment to the first question from beyond just the introductory stuff that the interviewer, the woman in pink there, has, is that she says, so in a nutshell, what happened? And Alexa says, well, I was having sex with my father from the time I was 7 until 16. Okay, that's the nutshell, and then they go back and she describes the very first incident, which occurred in Colorado, and then there were several incidents that she described in just remarkable detail. Any of you who've heard of dissociation is something that these victims go through, and depending on the level of abuse, the amount of abuse, you'll get drastic, consequences up to the point of like the split personality stuff that you hear about. She even describes dissociating at some point the first time that sexual intercourse occurred. She describes taking herself out into a field with birds and butterflies and stuff like that. You hardly ever get a victim to describe that, but she did.
Sorry,
Yeah.
You heard,
Go ahead.
I think you mentioned that she had denied it previously.
Yeah, she denied
I
it.
wanted to bring that to light that
Right.
I think there's an estimate of maybe 72% of recantation or kids, who don't.
Yeah.
They'll just flat out deny it or take it back if they have disclosed to a counselor or something, so that's.
Right, and delayed disclosure is almost the norm in these cases. It's very rare, especially when it's a family member or someone close to the victim. They'll disclose right away. It happens, but it's pretty rare. The norm is that they'll delay disclosure because they're afraid of coming forward. They're afraid of that someone won't believe them. There are all kinds of reasons. So we usually bring in experts in this. They're cold experts. They won't necessarily know anything about the case itself to kind of help the jury understand why a victim wouldn't come forward right away. Why, even when a family member asks them about it, they deny that it happens. So we have experts to come in and talk about that, to kind of educate the jury on that aspect. Okay, yeah. I have a practical section here that we'll go through in a second. So.
I wasn't ever going to tell anybody. I didn't have to see him anymore. I didn't have to deal with it. It was something that I could just put behind me. But as time went on, it got harder to realize that I didn't have my dad. I didn't have it. I mean, I have a dad, but I didn't have that father. And when me and my mom and Rachel decided to go look through all my mom's pictures, and started telling me before they looked through those pictures, they saw this picture of the first day he came to see me after I was born, and I don't know what it did. But I asked my mom, I was like, do you think we said this to him, he'll realize I'm his daughter and not just a toy? And she said something to the extent, do you not believe what he did to your sister? And it all came out.
So you can see the Kleenexes she's adding to the pile there. But so she was up there with her biological mother, who she basically didn't have much of a relationship with. They're going through pictures around Thanksgiving, and she sees a picture of her dad holding her as a baby, and she said that's just what lost it. So I had to try this case in one form or another 3 times. I got it for other reasons, but hung jury the first time. There was a middle case where there was involved drugs that was a not guilty verdict, and then we retried the sex case and he was found guilty at that point. But for the last trial, I basically revolved the entire trial around that statement and the circumstances in which she first disclosed. One of the clips that I was able to play at trial is this next one.
Easier. Is it over? Are we done?
I think so.
Yeah, it wasn't as complicated as I thought.
There may be some life from the dance, and I think that, but I'm gonna go over there for just a second and say, some doctor, anything else I forgot?
So there's a doctor who performed her physical exam that's watching the interview from another room, as well as the detectives. And so she's going back there to see if there's any other questions that they want her to ask that she might have forgotten. So the reason I was able to play that clip is because their definition of hearsay is an out-of-court statement made for the truth of the matter asserted. If you haven't had evidence yet, you'll have that language seared into your brain. So she doesn't make any assertions here, right? Nothing that she said is asserting about what happened in the past. The reason why I thought it was effective is that because they were accusing her of lying, of being an actress or whatever, I'm like, I think they told her that it was being recorded at the very beginning, but at this point, she has no idea if there's a camera. Or if she did know, she's forgotten. And just, if she's a high-level actress, if she's able to create all of the biological and physiological symptoms that you see there. I mean, not to mention, I was able to show what she looked like when she came in, her demeanor at the beginning, with the sweatshirt on and just the pile of Kleenex and everything else. And so anyway, that to me went a long way towards diffusing a lot of what the defense was trying to argue. Because that really, in a case like this, where it's not sexual assault, it's sex conduct with a minor or molestation of a child, there's no issue of consent because of the age of the victim. So the only defense in a case like this is that the victim's lying. So that was just from a legal perspective how I got that clip in. There was one more where I was able to use it under the same theory. And so after the conviction around the same time, Alexa and Jesse gave me this little reminder of them, which is something that's difficult to forget on a case like that. You have to try it 3 times. All right, so that's kind of the motivation issue as to why I'm still doing this after all these years, despite all of the frustrations that come along with this job. But I think we've got enough time to go through some like a practical aspect, if you can.
Well, that's what I was just gonna say. Your paralegals must have to sit through a lot of disclosure.
Right. So I don't know how much of you guys know about criminal. So I wanted to kind of touch on criminal disclosure. Discovery in the criminal process is different than in the civil process. Civil, basically, everybody has to give everything on each side. There are, requests for admission. There's interrogatories, all kinds of stuff that occur in civil litigation that don't necessarily occur in criminal litigation. You guys, if you haven't heard it already, I'm sure, legally, you've heard at least the term Brady material. So for my legal research students, I gave you the citation here with a pin site if you really want it. Just page 87. This quote comes from page 87. This is Brady versus Maryland, U.S. Supreme Court from 1963. So the term Brady material or Brady list, it all references back to this case. So the quote is, "We now hold that suppression by the prosecution of evidence favorable to an accused upon request violates due process where the evidence is material either to guilt or to punishment, irrespective of the good faith or bad faith of the prosecutor." So back then, Brady had to be something that the defense requested. It doesn't matter whether the prosecutor acted with bad faith or not, or the police, but it did have to be material either to guilt or to punishment. So it had to be something that would have likely changed the outcome of the trial. Back then, that was the definition. That bar now has been lowered significantly over the years. And the violation is that it violates due process if this evidence is not given to the defense. Just so you know, so the due process clause is just that portion of the Fifth Amendment where it says person shall not be deprived of life, liberty, or property without due process of law. There's a similar clause in the 14th Amendment, which applies to states as opposed to the federal government. So the 14th Amendment, remember, was part of the amendments passed after the Civil War. So now most of the amendments in the federal Constitution have now been applied to the states through the 14th Amendment. Not all of them. There's a few that are still out there that haven't necessarily been applied, including the second. And then Arizona Constitution has its own due process clause. So that's the violation legally. It's the due process violation when the state fails to provide evidence to the defense that could have helped him or her in their case. You may have heard about Deborah Milkey. She has now been freed, so she is no longer. She was convicted. She was on death row for quite a while for hiring two men to kill her 4-year-old son. The 2 men are still on death row. But there was a big problem with the state's case in that Detective Saldate with, I think, Phoenix Police or Maricopa County Sheriff's, I can't remember which. He interviewed her and she confessed to hiring these guys in some form, but he didn't record his interview. So it was his word against hers at that point. The fact that if he would have just recorded his interview, all this other stuff about his dishonesty, or some of them there were a few of them that certainly were upheld. A lot of them were kind of, he said, she said type things, but there was evidence that he had credibility issues that the state did not disclose to the defense. And during her appeal, her case was thrown out on the Ninth Circuit, and then there was a subsequent appeal through the Arizona Court of Appeals. But the reason why I'm putting this here is because now the bar is with the potential to have an important effect on the jury's determination. Compare that to what the U.S. Supreme Court said in Brady. You can see how the bar, as far as the material that the state has to disclose, is more than it was even under Brady. So in Arizona, we have rules of criminal procedure, as most of you know already. And there are rules of disclosure for both the state and the defense. The burden on the state, and the state's the one primarily disclosing evidence, but the defense has evidence too that it has to disclose. So I just want to kind of go through some of the rules. So initial disclosures in a felony case, the state has to make available to the defendant all police reports, all the information that it has at the beginning. Now, make available is a specific term as well. So if they're just reports, or if there's DNA analysts, DNA reports, or fingerprints, or firearms examination, all that stuff is just going to be given in report format. Now it's digital, PDF, or whatever. But if it's a physical cell phone, or if it's the downloaded contents of a cell phone, or if it's a physical piece of evidence like a ledger, we don't have to basically give the physical piece of evidence to the defense, because the state has to maintain chain of custody. So the defense has an obligation. We give them a list of everything that the police has in the case, and if they want to see it, they can make appointments to go view the evidence if they want. So it's not up to us to arrange for the defense and hold their hand and go over there and take them through all the evidence. They have to select which pieces of evidence they physically want to see. If it's in paper format, if it's easy to disclose, we will do that.
And as far as phones, you can download all the information.
Right.
Share that.
And we'll give them a copy digitally of the contents of the phone. But even now, all that stuff, like there's new versions of the programs that download and analyze the evidence from cell phone coming out all the time. So, eventually the phone is in evidence. If they want to get an expert to go download it themselves, they can. I mean, we're not responsible. Oh, we have a new version of this, we better give you a new download. That's where make available comes in. The defense has some responsibility to use their own experts if they want. And so the state is supposed to make all this stuff available by the time of the preliminary hearing or the arraignment. Now, in the biggest counties in the state, they use grand juries. So normally we're not doing preliminary hearings. So a preliminary hearing, you might hear about them sometimes, where the state is putting on their case to the judge to determine whether there's enough evidence to go forward and indict the defendant. 99.9% of the time, we're going to a grand jury, getting the indictment that way, and then scheduling an arraignment. There are small counties, however, as I found out when I did a conflict case for Greenlee County, where they don't have grand juries because they don't have enough people. So they have to do preliminary hearings on all felony cases. So we had to do a preliminary hearing on a case where the county attorney, the ex-county attorney, and a sheriff deputy were victims. They had a conflict. So supplemental disclosure. So the disclosure doesn't end after the initial. The rules allow for anything that's supplement. The state still has to provide recorded statements, any statements of the defendant, all reports by law enforcement, expert witnesses or expert reports. The state has to disclose them, the name, address, and qualifications of the experts, a a summary. If they're not writing a report, we have to give them a summary of what they will testify to if they don't go to the point of writing a report. Documents, photographs, tangible objects, electronically stored information like we talked about with cell phones. If there are prior convictions of the defendant that we might be able to use if the defendant chooses to testify, we have to give notice to the defense of that. Any other acts that might be admissible at trial, we have to disclose those as well. And then here's the specific subsection designed to cover what Brady was initially mandated is under B8 that tends to mitigate or negate the defendant's guilt. So it's a different definition than what Brady had back in 1963. But so we just, anything that even looks questionable, we have to disclose to the defense. If there are jail calls or electronic surveillance that we're going to use, we have to give those, search warrants. Now, the scope of the state's under subsection F, the state's disclosure extends to material information in the possession or control of the prosecutor, law enforcement, or any other person who is under the prosecutor's direction or control. This possession or control has been the subject of litigation in a number of different cases. Like there were several different versions of the software used on the blood alcohol machines that defense was demanding that all the source code had to be provided from the manufacturer. There were several fights. I haven't seen one recently, but there were a couple of stages back in the 2000 to 2012 area regarding that. And ultimately, the software company said, no, we're not giving it up because it's proprietary. And it wasn't in the state's possession or control, so the defense had to try and file their own motion to get it that way. There's also issues about whether DCS is a state agency within the state's possession or control. It's basically the DCS, if they have information, they have to give it up to us and provide it to the defense as well. And there can be disclosure by a court order. The defense has to, if it's not some of that stuff that the state already has in its possession, then the defense can move the court to order that it be provided to them, but they have to demonstrate that they have a substantial need for it. That's another area of significant litigation. And that the defendant can't obtain the same information by other means. Oh, this is disclosure of rebuttal evidence. So ultimately, after the defense provides its disclosure, which we'll cover here in a few minutes, then if the state has information that it intends to use as rebuttal, so for those of you who haven't seen criminal trials, the state puts on its case, then the defense, if they choose to put on evidence, they can, including the defendant testifying if he or she so chooses. Then the state gets the last word, so to speak, with rebuttal evidence to counter anything that was brought up specifically by the defense during its case. So if the state specifically has evidence that it's now become aware of as a result of the defendant's disclosure, then we have an obligation to provide that to the defense as well. And then capital litigation has its own rules because there's just capital cases, death penalty cases have this penalty phase aspect to them that have all kinds of rules that go along with that. So there's always disclosure going back and forth on both sides of that. There's specific rules regarding capital cases. Okay, so that's rule 15.1. That 15.1 is the rules that cover the state's disclosure obligations. 15.2 is the rule that covers the defense of disclosure obligations. You'll see a lot of overlap here. The language is similar to what's used in rule 15.1. But specific to the defendant is that the defendant has to submit himself or herself to physical characteristics. So if a photo lineup wasn't done and the state has reason to, that there's a new witness that might be able to identify the person, he or she will have to appear in a lineup, provide a voice sample, be fingerprinted if they weren't already, or palm printed or foot printed, pose for a photo if they haven't got that already. So we will file a motion for physical characteristics sometimes if the police didn't get it as pursuant to a search warrant to begin with. Try on clothing. Prosecutors are probably not likely to try that after the OJ trial, as you can imagine. If you're going to do that, you're going to do it some other time. Make sure you know what you're doing. Well, I've done several handwriting cases. So there was a murder case in which it was 2 or 3 people, drug deal gone bad. Each side was trying to rip each other off. One side, had either got their guns off first or whatever. So 2 of the parties were dead. But then they found sunglasses that were left behind, and it matched one of our primary defendants. And then when they did the search warrant at the defendant's house, there was a ledger that was found that had all these diagrams of how the marijuana was coming up from Mexico, coming up to Tucson, how it would be, distributed to Miami, to Philadelphia, and other places. And there was all kinds of written instructions and communications and that sort of thing. The defendant said that no, it was his brother's journal. The brother wasn't even there at the time. So the defendant was also had a side job as a real estate agent. So I was able to find a bunch of documents with his handwriting at the assessor's office, at the recorder's office, I'm sorry. So he had all kinds of his property sales. He had several samples of his own handwriting, and there were very, very significant and distinguishable handwriting samples. So we made him do a handwriting sample, and then we were able to pull in a lot of that stuff from the recorder's office to kind of show, yeah, that was his journal, not his brother's. Defendant is entitled to have his attorney present during any of these things. Okay, notice of defenses. So this is one of the things that I will say a lot of defense attorneys just ignore this rule, to be honest, because the judges don't often hold them accountable, so we have to ask for it. But anyway, the defense is supposed to provide a notice of defenses, which include, you see all the list of them there: alibi, insanity, self-defense, defense of others, entrapment. What oftentimes happens for attorneys who are, well, not as diligent as they should be, they'll just check off 5 or 6 of them, even though they don't apply. And then what they're also supposed to do is provide for all the witnesses that they intend to call. They're supposed to link them up with the defenses. So if there's an alibi witness, they're supposed to let us know, okay, yeah, this witness here is our alibi. This person here is going to support the defense of others or whatever. I can tell you that oftentimes some defense attorneys are very good about it. A lot of them are not so good about it. They won't make those links, and so I'll have to file a motion to ask them to clarify. They're supposed to they have the same obligations for expert witnesses that we do. So if they have experts that they're going to call, they have to give us their name, address, and if they have prepared a report, they have to give it to us. If they have not prepared a report, they have to give us a summary of what they're going to testify to before we interview them. So a lot of this stuff is very similar. They are supposed to provide their initial disclosure 40 days after arraignment. That's where honestly, there are very few defense attorneys who follow this particular obligation. So oftentimes, I won't even bother with it unless I know the case is going to trial. As soon as I know it's going to trial, then I will contact the defense attorney directly, say, hey, you guys haven't filed your 15.2, can you please do so? And so you'll see some of this stuff is very similar to the same equivalent disclosure obligations for the defendant as it is for the state. We can ask for a court order if we have a substantial need for the material that the defendants say they don't have. So you can see a lot of this stuff is similar. Now, there are some rules that apply to both parties. So there's a continuing duty to disclose. Sometimes these cases, I've got a case now from 2015. It's my oldest case. It was supposed to go to trial at the end of this month. Now it's going to be continued again until January or February or March or whatever. So you can imagine that there's disclosure that comes along if the case is 8 years old. So that just because you've disclosed stuff, for the first 2 years doesn't mean your obligation ends for either party. So you're supposed to provide, at minimum, your disclosure has to be 7 days before trial. But really, if either party knows that they've got additional disclosure coming and it's significant, they need to anticipate that 30 days before trial and let the other side know. Like 7 days, if either party has a new expert and we get the report 7 days before trial, that's not good enough for the other side to be able to compare. So there are sanctions that are available for disclosure violations. What we're supposed to do, though, is before we go to the court asking for some kind of sanction, is that we're supposed to work it out on our own. So each side is supposed to communicate with each other, hey, you're supposed to go through and figure out if you've got anything that you don't agree on, then let the court know, let the court decide, as opposed to judges get really angry at both sides if you just come in with motions for sanctions where you haven't tried to work it out on your own. So it's to both sides' advantage to get that stuff done as best as they can before they get there. But some of the sanctions that can be imposed by the court, since I'm running out of time here, are the court will evaluate how serious the disclosure violation was, but ultimately the court can preclude or limit a witness from testifying, the use of evidence or arguments that are supporting such evidence. The court can dismiss the case with or without prejudice, particularly on the state, if there's a significant violation. Grant a continuance or declaring a mistrial, hold a witness in contempt, hold a party or person in contempt, imposing the cost of continuing the proceeding, like calling the jury in, that costs money to the county. So if something is a blatant violation, I've seen the judge impose costs of jury commissioners on occasion. It doesn't happen very often. Or any other appropriate sanctions. So those are all the risks that you take, mostly on the state, because we don't have a constitutional right to a lot of stuff. The defense does. So the real disclosure obligation is on the state, and those are kind of sanctions that can be imposed. I'm running out of time, but this is a trial that I did on a conflict case in Maricopa County that resulted in a not guilty verdict, in large part because of some failures to collect and disclose information regarding silent witness tips. I'm gonna blow through this. Kiera Bergman is our victim. She was last seen on August 4th of 2018. The defendant was the last one to see her. He picked her up at work. Her body's not found until a month later. So you can see she's wearing the same sweatshirt. There was no cause or manner of death because of her decomposition. It was likely strangulation, but that was one of our problems at trial. But what happened in this case is because she was a missing person at first, the police put out missing persons press releases and bulletins online, and they had a bunch of people calling in. Now, probably 95 to 97% of them were all bogus and easily, they had people calling in saying that they were psychics or whatever, But then you had some people saying that she was in Texas, and they knew she wasn't in Texas. But there was one in particular that the police didn't follow up on, and it never got delivered to the state until 2020 during interviews. There was one person who lived 1.5 miles away, 1.3 miles away. She says she's got a picture of a domestic violence incident involving an African-American female that she sees in a black male. She took a picture of the car as it was going away, and you can see the license plate on it, and it happened at 12:30. So she was last seen at 10:30. The defendant says, based on his phone messages, that he said that she stormed out of the house at 12:09. None of this was disclosed. The police didn't follow up on it properly. It wasn't disclosed to the prosecutor, and so it sat there for 2 years, and nobody knew about it. The defense finds out about it during interviews. Ultimately, the court just, you can see, she wasn't even anonymous. She writes down the license plate and the year and make of the car. She wasn't even anonymous, so easily the police could have called her, and it would have been easy enough to follow up on that car to see who it was, as opposed to us trying to do it 4 years after the fact. It was nearly impossible. But ultimately, the case was dismissed by the Maricopa County Superior Court, and then after that fact, the Maricopa County Attorney's Office has a conflict because this witness used to work with the prosecutor that was assigned. It was a weak reason for a conflict. They conflicted off. Our office took it, and some stuff rolls downhill, I guess. And so I got my co-counsel and I did the best we could with this case, but there were a lot of problems, and it was a difficult case to try, and ultimately the jury found him not guilty. So that is a significant problem with disclosure of something like this. So, something like this, if you've got silent witness information, this clearly falls under Brady because, it's so close in time. And it's, she said it looked like the girl. She didn't identify, Kiara specifically, but she said it looked, very similar. The phone evidence didn't support that. The phone evidence actually showed that she was still at the apartment at that time. The defendant was the one using the phone. But anyway, so this is the issue with disclosure, and that's why paralegals need to work with their prosecutors, and the police need to inform the prosecutors about stuff that they have, because we're on hook for anything that the police, fail to collect or don't disclose to us. It's, we can say, yeah, they didn't give it to us, and of course, I don't care. Mr. Jensvold, that's not my problem. You're responsible for the police agency's disclosure. So anyway, I think I'm out of time. So that's a lot, I know.
Police didn't follow up.
What's that?
But the police didn't follow up. That's probably why they didn't give it to you.
And part of the problem is that Phoenix Police is a giant agency, and so they've got so many detectives, they've got a missing persons bureau. So the missing persons detective, he was doing his job, and he was doing a lot of stuff, but then they've got homicide taking responsibility for some of it. They had no one that was dedicated to following up on all these tips. And you get one like this, you don't follow up on it.
Right.
This is what happens.
Do you have any idea, did that defendant
We can
ever
get
have
everyone out, so
additional,
we have a class coming in and then.
did he have any additional crimes? I'm just
Oh,
curious.
he had a car theft case out of San Diego. There were prior domestic violence incidents between him and the victim.
I got it.
If there's any recency.
Oh, not